All right. Hello, everyone, and welcome to the seventh Talking Evidence episode. So the Talking Evidence series is a series that is part of the Dissect project, which I will explain in a little bit. But essentially, we discuss how evidence is assessed in international human rights law, and we usually involve people who are experts on the topic, but who are not necessarily part of the Dissect project per se. So the idea is that we extend the discussions that the Dissect project has been having for 5 years now with people who are a little bit outside of the project, but working on similar things. Today, we will be discussing the evidentiary regime of the Inter-American Court of Human Rights. And we have two speakers with us today. So first, Álvaro Paúl, who is a law professor at the Pontificia Universidad Católica de Chile. He has a lot of experience researching the Inter-American Court of Human Rights. His PhD thesis was about evidence at the Inter-American Court of Human Rights, but he's also written many articles about it, which is why he is invited today. And today, his research focuses on the role of human duties in human rights law, how international courts interpret them, and then what they do with them. Professor Marie-Bénédicte Dembour is at the University of Ghent and also the PI of the Dissect project. She has worked extensively on human rights, particularly, but not only in the context of migration. And the Dissect project examines the role of evidence in international human rights adjudication, paying particular attention to the role of the adjudicator in the process. So put simply, in situations where the facts are contested between the individual and the state, how does the adjudicator navigate the evidentiary requirements and burdens that are placed on the individual and on the state in such a way that justice happens? The Inter-American Court of Human Rights is one of obviously the three regional human rights bodies, and together with the Inter-American Commission of Human Rights, it interprets and ensures the respect of the Inter-American Convention of Human Rights. Its assessment of evidence is often considered to be more generous towards the applicant than its sister courts, in particular, so the IACtHR, and the African Court of Human Rights is often considered to take lessons from the Inter-American Court. And this might be because the Inter-American Court is considered to have a strong focus on finding truth and also acknowledging the inherent inequality of arms between the individual and the state in human rights proceedings, though of course some scholars also question this assumption. So today we're going to zoom in on these evidentiary questions at the Inter-American Court of Human Rights in order to understand the similarities and differences in the way that evidence is assessed by the Inter-American Court and the European Court of Human Rights, as well as explore some of the contemporary challenges that are faced by both courts. So to begin, and to get a little bit of an idea of the Inter-American system in comparison to the European Court of Human Rights, would it be fair to say that evidence is particularly crucial for proceedings at the Inter-American Court, and maybe even more so than at the European Court of Human Rights? And maybe I give the floor first to Álvaro for this question.
Thank you very much, Isabella. Thank you very much for the opportunity to be here talking about these matters. I would say that yes, that the evaluation of evidence, the assessment of evidence, is much more relevant before the Inter-American Court of Human Rights than before the European Court of Human Rights, because, well, the Inter-American Court of Human Rights analyzes evidence in most cases it studies. Why is this? There are many factors that I think come into play. One of them is that because of the fact that some domestic proceedings are very long, or because of other reasons, many cases reach the Inter-American Court of Human Rights without having actually exhausted local remedies as exceptions to the exhaustion of local remedies. And somehow the court, if that is the case, cannot base itself on the evidence procedures of domestic courts. Also because the Inter-American Court of Human Rights considers that that claiming the exhaustion of local remedies is a right of the state. So it may analyze cases where the local remedies haven't been exhausted if states don't claim it, or if states don't claim it within the special time frame that they have according to the Inter-American Court of Human Rights. So that's one of the reasons. Another reason could be the sort of distrust that the Inter-American Court of Human Rights has on domestic courts. Sometimes this distrust could be it can be due to existing problems. For instance, it happens that in some situations or some violations are very much linked or presuppose some sort of lack of independence between the judiciary and the executive. Let's say cases where we talk about enforced disappearances that could be more recent, or when there is some sort of continuation of the judiciary between the moment where there was this sort of practice by the state and so on. And also, well, because of something that also happens with the European Court of Human Rights, which is that sometimes violations are linked to statutes or things that cannot be claimed before the judiciary. And even though some of these violations refer to statutes, and therefore they wouldn't require an assessment of evidence, there's another issue that the Inter-American Court is interested on, and which requires evidence, which is the reparation of victims. So the system of reparations of the Inter-American Court of Human Rights is extremely complex. When I talk about reparations, I mean remedies, the remedies that are given to the victims. And the court is interested in knowing what happened in a particular case, because it wants to see, well, how the victims were affected, how could we solve this problem. So the court, let's say, grants not only compensation, economic compensation, but also requires the payment sometimes of scholarships to the offspring of the victims. It requires engaging in some sort of a psychological remedy and so on. So it needs to know all these sort of details of the victim. So that's another reason why the court engages in this sort of evidentiary assessment. Oh, and another matter that is interesting is that when we talk about victims before the Inter-American Court of Human Rights, we don't only talk about the direct victim. We also talk about the relatives who are considered victims as well by the Inter-American Court, because the court considers that the relatives saw their personal integrity affected, let's say, psychologically or morally. So those could be some reasons why the evidence is so important before the Inter-American Court. And I could say more things, but I think that I have already spoken too much about this.
There's already many reasons. Marie, do you want to add anything?
Yeah, maybe. So Álvaro has talked quite a bit about the Inter-American Court, rightly so, because that's really his area of specialism. So maybe I can add a few things about the European Court of Human Rights. I think what is important, and it's already in a sense been mentioned by Álvaro, is that the European Court, expects the national remedies to have been exhausted before the claim comes before it. And during these domestic proceedings, the facts should have been established. As a result of which, the default position in the Strasbourg system is that, in a sense, the European Court would not need to look at the facts because they've already been established. In the Inter-American system, where some of the claims are much more, in a sense, involve more gross violation of human rights, these violations are not have not been established at the domestic level. So the Inter-American Court will possibly have to establish them for the first time, or dismiss what's been found at domestic level because of it not being trustworthy. This, of course, can also happen in the European system, but the European system has evolved in such a way that the default position from the court is that it trusts the domestic authorities. And of course, then it has a lot of implications for evidence, because if it trusts the findings of the domestic authorities, well, there is nothing to be proven. The facts are established. Of course, that result is in itself potentially problematic. But that's the whole, in a sense, the tension on in the fact that we have a court, which is an international court, which is there to check what has been happening at national level, but what the lawyers calls the principle of subsidiarity means that in a sense, the European Court should not interfere too much with what has been done at national level, and should, in a sense, well, trust. I mean, there is this principle that the default position is to presume that the state is acting in good faith in the proceedings before the court and previously, and so theoretically, and the European Court would be there for issues which used to be described as issues of fine-tuning. So you don't need to establish the facts are there, but what you need to decide is whether the measure taken by the state, which is not contested, would be proportionate in the circumstances of the case. So it would not be to think, well, did the army or a paramilitary force disappear people with the state condoning this, or possibly even encouraging it, or maybe even ordering it. So in the European system, we are supposed to work to be dealing with less contested facts. I
so
think
this is, oh, sorry.
I think that's problematic in itself, because I think that the issue of when should facts be reopened or when should facts be accepted should be a question that is really looked at.
So this is touching.
It is. Sorry.
I will give you the floor.
Sorry.
I'll give you the floor in 1 second. So this is touching on that issue of international human rights courts not operating as fourth instance courts. So the idea is that they should not re-examine cases that have already been decided by national courts.
Three times. At first instance, on appeal,
yes,
and last resort. So 3 times before the domestic court. So that's why we talk of fourth instance at the international level.
Except if it finds that the national courts have not adequately addressed the human rights claim. So, Álvaro, do you agree then that the Inter-American Court reopens the facts perhaps more easily? And also, you can reply to Marie.
Sorry, sorry for the interruption, but I think that the Inter-American Court doesn't even ask itself if it has to reopen the facts. I mean, for the Inter-American Court, the findings of domestic courts are just, perhaps this is a way you could say it, are just an additional evidence towards its own role of establishing the facts. So the Inter-American Court of Human Rights considers itself to be absolutely autonomous for the determination of the facts. Not only autonomous from the findings of the Inter-American Commission of Human Rights, because the Inter-American Commission could find some facts, and the Inter-American Court could say, okay, no, I'm dismissing the findings that you had. So the Inter-American Commission doesn't act as a I don't know how you call it in English. I think it's a facts tribunal or something like that.
Fact-finding.
Fact-finding
body.
Yes, a tribunal of facts or something like that. Yes. So the court considers itself to be autonomous from the findings of the commission, but also from the findings of domestic bodies. And I agree with Marie on the fact that there are some cases in which you have to reopen the facts, and you can't blindly trust what is defined by domestic bodies. However, it is also true that international courts are subsidiary courts, and that's not only some sort of differential treatment to states. It is based on the fact that international courts have real limitations, and those limitations are manifold. What do I mean by this? That their analysis of the facts is something that can happen 20, 30 years after the facts have already occurred. You have to think that before the Inter-American System of Human Rights, the prior phase of the Inter-American, before the Inter-American Commission can last for 15 years, who knows? So that's one thing. The other thing, another limitation of international courts is that their immediacy with the evidence is also limited. So they cannot examine the same number of witnesses that domestic courts were able to do that. They don't have the fine tune that judges from the country itself can have regarding the facts or the way people behave, the way people say things. In some places, people may say things very directly, bluntly. In some other places, witnesses may use different ways of expressing themselves, and all that fine-tuning is something that international courts don't have. So there is a problem in not, let's say, opening the case for an evidentiary analysis, but there's also a problem on the other extreme, not knowing your own limitations. So subsidiarity is not something that is just deferential to, let's say, state sovereignty. No, it is something that reflects or is a consequence of reality. Domestic courts are in principle better prepared for assessing evidence. And that is something that is problematic, I would say, with the Inter-American Court of Human Rights, because it often isn't aware of its own limitations. So there's a problem in both extremes. Mm-hmm. I don't know if sorry.
Marie, you go ahead.
Great. Two things. The first is a question or a clarification, or Álvaro, does the Inter-American Court not refer at all to what we call the no force instance principle? It does not. Does it sometimes say that that at least in principle it should not act as a force instance? It should not be an appeal court for the facts. Are we not going to find that statement in its jurisprudence?
No, we do find it. We find it all the time. Mm-hmm. But when it comes to the European Court of Human Rights, the European Court of Human Rights refers to the fourth instance doctrine, and it has clear consequences. That means that the European Court of Human Rights will not reassess or redefine the facts in principle, and it also will not give its own interpretation of domestic norms. So I would say that those are the two consequences of the fourth instance doctrine before the European Court of Human Rights. However, the references to the fourth instance before the Inter-American Court of Human Rights are references whose consequences are not that clear. Are not that clear, not only in relation to evidence, not only in relation to the interpretation of domestic norms, but even when it comes to the effects of this in relation to the exhaustion of domestic remedies, and I would say to the exception of the exhaustion of domestic remedies. So it is something that requires additional thought, additional research. So if some of the listeners are thinking about a PhD thesis, perhaps they could assess the fourth instance doctrine before the Inter-American Court of Human Rights, because there are some papers on the matter, but they actually aren't able to find out what does this doctrine mean before the Inter-American Court, because it requires a very much in-depth study.
Yeah, because we know, of course, I mean, the no fourth instance principle is linked to subsidiarity very clearly. You know, it's a principle which makes it possible to activate subsidiarity, to give it some kind of consequences. And we know, I mean, the European Court, you know, has been told by governments and has also accepted for itself that it has to act in a subsidiary way. Subsidiarity is less clear in the Inter-American jurisprudence, because the Inter-American Court is more interventionist. I think it would be very difficult to contest that. And, you know, right from the start, I mean, the very fact that the court used to say that it was pro homine in its approach, and that now it says, I think it says it's pro victima. I mean, the very idea of saying pro victima, I mean, obviously it's not going to say, oh, we are against the state. But if it's to the advantage of a party, it's going to be to the advantage of the alleged victim. It's not going to be to the advantage of the state as such. So the differences of orientation are very clear from the start. And then they manifest themselves in the way the two courts approach evidence. And the result is that the Inter-American Court is going to deal with evidence, be willing to deal with evidence to an extent that you are not going to find in the European Court.
And if we go now a little bit further beyond, so the no fourth instance principle, and we look at some of the reasons for which the evidentiary standards, so not just the no fourth principle, but also how evidence is assessed by the judge in human rights adjudication, is often considered to be very flexible. That's the more generous interpretation, or very unclear, which is, I guess, less generous. In the DISAC project, we've often found that one possible reason for this lack of clarity is that these are systems that blend common law and civil law because of where the judges come from, what tradition they're trained in, and that this means that then the evidentiary regime is a kind of hodgepodge of two different approaches that don't necessarily create a very coherent framework. What if we're looking at the Inter-American Court of Human Rights, would you say that it operates more closely to the civil law or the common law tradition? And perhaps you can also link this then to how the Inter-American Court talks about sana critica.
Just a small question for you, Álvaro.
Sorry. I thought you wanted to add an additional question. But yes, I mean, the interesting thing is that as opposed to what happens in the European system of human rights, where you have only a couple of states that belong to the common law tradition, in the inter-American system of human rights, or let's say at least in the system in which the inter-American system of human rights is located, which is the system of the Organization of American States, 1/3 of the states belong to the common law system, because you have not only the US and Canada, but you have many small countries in the Caribbean, Anglo English speaking countries that many people sometimes forget, but they do belong to the common law system, and it is also, let's say, some sort of public to which the inter-American system of human rights should speak in order to somehow prompt them to join the system. So the factual, the substance of common law is much stronger in the inter-American system of human rights. However, in spite of that, the reference to common law features within the inter-American system of human rights is very, very slight. Actually, something that is very, I don't know, how can you say, it's very funny in a way, is that there has been plenty of discussion in the English-speaking world about the standard of proof of the Inter-American Court of Human Rights, but that's based on a judgment in English whose translation is a mistranslation.
Whose translation is what?
It's a mistranslation.
It's a mistranslation.
Yes, so I wrote a paper on the standard of proof where I refer to that article and I put the Spanish version and the English version, and I say, no, here there's a mismatch. So when English-speaking scholarship speaks about the standard of proof in the inter-American system, there's often this sort of problem that it's based on a mistranslation. So yes, there's not that much reference to all these, let's say, detailed regulation of evidence that is much more common to the common law system than to the civil law system. The Inter-American Court does refer to some, let's say, legal concepts, such as presumptions and so on, sana critica, as Isabella was telling us about, but it's not a very deep consideration of evidence as it would be a consideration that people in the common law world could have. So it's you could say a little bit more basic. We're not saying that the civil law system is something basic in a bad way. It's just the way it is. I remember when I did my master's at a British university, and there was a course called Evidence in Civil Procedure or something like that, which was a full course. That's something that we wouldn't think that possible probably in common law systems, in civil law systems. And that course wasn't open for civil law lawyers. So I couldn't take that course because it was open only to common law lawyers. That's just an anecdote to show the difference that common law lawyers place in evidence versus civil law lawyers. Well, sana critica, the court often refers to sana critica. One of the concepts, evidentiary concepts it refers to is sana critica. The readers of the English version of the judgments of the court may not be that aware of the reference to that concept, because the court translates that concept in 10 different ways. So sound judicial discretion, sound discretion. Once I read healthy criticism, which is a very bad translation, but it is a concept that is interesting for civil law lawyers, but perhaps not even that interesting for civil law lawyers. Why? Because sound criticism, sana critica, or sound criticism simply refers to the concept of rational persuasion, to the concept that for English speakers would be rational persuasion. What does that mean? simply that evidence is something that the judge must ponder, and the judge isn't limited by rules of legal proof. What's legal proof? Legal proof is a concept that stems from Middle Ages, where there were specific items of evidence that were foolproof. For instance, confession before a court was a foolproof. The statement of two witnesses of high credibility was foolproof. The statement of one witness of strong credibility was a half proof, let's say, or prueba semi-plena. So there was this sort of medieval mechanism of giving weight to specific kinds of evidence. It was a system that stemmed from perhaps some distrust on judges, but was medieval. Some people say that even it had some influence on the on obtaining confession via torture, because it was a way of obtaining this foolproof. But it was something that for common law lawyers isn't that relevant, because Bentham already argued against this system of legal proof. But for heirs of the Hispanic system, this system was present in the Siete Partidas. It was a legal document, a Hispanic legal document that was received by the legal systems of Latin America. And then only after independence, it was the case that states started to depart from that system of legal proof, where everything was some sort of mathematical system for proving facts. And I don't know, in Chile, there are still some remnants of legal proof for the, let's say, for some civil procedures. So it is something that still exists in Hispanic systems to a very small degree and in a very few specific countries. But sana crítica is something, it's just what you could call rational persuasion. So it's nothing new for common law lawyers and for people who know about international systems, generally speaking. So as Isabella says, it is a concept that the court often refers to, but it's not something that is that new, perhaps. I don't know if I answer all the questions that you asked, and in an appropriate manner.
Yes. Yes, you did. And actually, you touched upon the standard of proof. So could you tell us a little bit more about what standard of proof the Inter-American Court has adopted? And then maybe, Marie, you can step in and contrast that with the European system.
Again, the concept of standard of proof is not a concept that is very much common in civil law systems or Hispanic civil law systems. At the most, we would say, or most systems, Hispanic systems would say, there's this standard of beyond reasonable doubt in criminal systems. But there's not that much development of the different standards of proof as it happens in the common law system. So you could say that, generally speaking, beyond this idea of beyond the reasonable doubt, which is also, you could say, an importation from common law systems, because in principle, what we used to use was the principle of in dubio pro reo, which meant that if you're in doubt, you have to favor the person who is incriminated. Then we adopted the terms of the common law system, but the substance is more or less the same. But in civil laws, in civil proceedings, there's not that much of a discussion about the standards of proof. There's not that much development on the matter. There has been a recent development, but it's not that clear. And what's the standard of proof used by the Inter-American System of Human Rights? You could say that perhaps it is case sensitive. It is case sensitive and perhaps even fact sensitive. The court has said that it doesn't use the beyond reasonable doubt standard of proof. So the court is clear on that. And why is that? I think that it is because of a very reasonable argument, which is that the court doesn't judge people for criminal action. So people in principle are not sent to jail because of the judgments of the Inter-American Court, and that's the reason why it doesn't operate with the criminal law standard of proof. There are some caveats that we would have to make to that statement, because there are some cases where the Inter-American Court refers to specific individuals as related to a particular human rights violation, which is a criminal offense domestically, and sometimes the judgments of the Inter-American Court have effects on the freedom of those individuals responsible for violations domestically. So the rationale that I just gave is in principle right, but it should be subject to some caveats. So in principle, the court would use, I would say, the preponderance of evidence standard of proof. Why do I say that it's case specific? Because since there's no real development or no real how can I say it? Yes, development could be the word. There's not much theorizing of the standard of proof before the Inter-American Court, and the court doesn't do that analysis in its regarding its own procedures, and it's understandably so, because it's not a concept that is that much common in civil law systems, and the court isn't that much interested in importing common law concepts. It is only I don't know, reasonable that the court won't develop that concept. But because of this lack of theorizing within the concept the court in some cases just varies a little bit, and it has been the situation in some cases that the court has used an amount of evidence, to say it somehow, that you could say, okay, here the court, okay, is not using the beyond reasonable doubt standard of proof, but somehow it is using the clear and convincing standard of proof, perhaps. But you could say that generally the court uses the preponderance of evidence or the probability standard of proof.
Marie, do you want to contrast that?
Yeah, there has been a lot being said, so thank you, Álvaro. It's very interesting. I'd like first to go back maybe at one of the first things you said. So we know that the Inter-American system applies throughout the Americas, and of course, then there are a number of common law countries, including the Caribbean, but of course, including the US, Canada. But because the US and Canada have not really signed up and ratified the convention, so as they are outside the American Convention on Human Rights, and even though we know that Judge Burgenthal, who was a US citizen, was was part of the founding of the court, and so one might have thought that there would have been an influence there. But I suppose that, in a sense, the common law influence on the jurisprudence of the Inter-American Court would not be that prominent. Am I right there? And that, I mean, as you say yourself, in terms of the standard of proof, the court does not refer to that standard. It occasionally says, well, we're not going to use beyond reasonable doubt. This is not a criminal, we're not a criminal court. We are a court of human rights. It's not appropriate. But beyond that, there won't be, am I correct that there won't be much reference?
Yes, you're correct. I mean, sometimes there are some concepts that are, you could say, common sense concepts, and you can translate them to legal concepts. So sometimes the court talks about the amount of evidence. You could say, okay, amount of evidence, that refers to the weight of evidence, perhaps that refers to the standard of proof. So sometimes you have to engage in this sort of translation from common sense understandings to legal concepts. And it is true that Judge Bergenthal was a judge of the Inter-American Court, but he isn't the only common law country. Almost always been a judge from the Caribbean, English-speaking Caribbean. That's not always the case, but historically that was the case. And as far as I can recall, I may be wrong, but I think that Judge Bergenthal was a judge sitting together with Judge Jackman. I'm not that sure about this, but there was probably a moment where there could have been two common law judges sitting sitting in the court. I may be wrong, but that could even have been the situation, and that's I don't know, 40% of the court. So that's a big number.
So that was one thing. I mean, to me, what is interesting is, Isabella will know, I kind of think that it would be useful for international human rights adjudication to rely more on the concept of the standard of proof, that the flexibility that know beyond reasonable doubt, and then beyond that, well, anything you like, so it goes to, in the French way of saying things, intime conviction du juge, what the judge feels in themselves, which then exactly does not go into the amount of evidence that you were talking about. You don't have to explain why you are convinced or not convinced. So, in the Dissect project, those of us who have been thinking about these issues in the past year, we kind of feel, well, if we could say, for example, that at the early stages of the proceedings, the standard is law, and then through the proceedings and when you arrive at the merits, it becomes the balance of probabilities, which is the same thing as the preponderance of evidence. In mathematical terms, it comes to 51%. It's more than 49 preponderance. It's the balance. It goes a little bit more. That, we feel it's useful, because if you don't have that, and then you have some cases where there is a lot of evidence, really a lot of evidence, and more than you need, there is potentially a danger, especially in the European system, that the judges of the court would remember, in this past case, we found a violation, but there was much more evidence than we have today. We don't have enough today. So that trying to articulate what are the minimal requirements, and thus also opening the way to managing to find, okay, actually, here, well, it's less than last time, but it's good enough, would be useful, which is probably, it's not a problem which will be so prominent in the Inter-American Court, as the Inter-American Court, to begin with, already has this inclination to look back at the facts and to make its own assessment, rather than blindly following the domestic authorities, if the domestic authorities have done their job. I mean, as you were saying, well, the Inter-American Court gives itself the freedom to act autonomously, because it regards it as its mission. We have to look whether there is a violation of human rights. We're not going to be bound by what another body, you said the Inter-American Commission, but I suppose we could also say the domestic authorities have said previously. It's our job to take the judgment. I find this discussion really interesting, because also, and when you're talking, you were also mentioning sana critica, and saying, well, sana critica, well, what does it mean? It just means, some discretion. Be sana, sane, healthy or reasonable, or I mean not absurd, that there is something which is sane. Criticism, so exercise judgment, exercise reason, don't go for the arbitrary, don't go for what is contradictory, which does not stand to reason. And you say, well, it does not really add anything. And I kind of think, well, if you were taking this motto of sana critica seriously, I mean, it's a big ask to refuse to let yourself go by what is not supported by logic once you begin to look at it. So personally, I think I cannot help liking the idea of sana critica, because I think that theoretically it really gives a very high standard of
Yes, that's a fair point. That's a fair point, and it also somehow shows that that the court has also somehow to convince you that the findings that it reaches are based on evidence. So it's just not just discretionary. It's not something discretionary. Yes. So in that sense, the concept is important. Yes.
And I'm sure, but here I don't even want to criticize any court, because it's very easy as academics. We have theoretically, we have the time to do research. We hope so, but at least we can, we are not absolutely forced to publish and to come with a definite conclusion before we feel ready to do it.
Yes.
Well, of course, there is pressure on the part of the court. The judgment needs to come out. And also, the court will always, except at the very, very lower domestic level, will always be made of a number of individuals who then must hopefully come to a collegiate opinion. Yes. Because otherwise, if it's not collegiate and they all say, well, actually, I think this because that, and the other one says, well, actually, I come to the same conclusion, but for completely different reason. I don't find the first reason convincing, and then the third one adds something. It wouldn't feel weighty for the public who receives it. So the judges are in a difficult position. So what I wanted to say, I can imagine if there are other prospective doctoral students listening to us, that another good topic of research would be, does the Inter-American Court really follow sana critica? Where do we see the rules of logic either being applied or not being applied? And I think there would be a lot of cases where they wouldn't be applied. We know that also from our everyday life. That's why I'm saying, it's not that I want to be critical. People who are logic, who make a profession of going for logic, are going to tell us all the time, you're not logical here. You're not logical. You're saying things which don't hold.
Yes. May I say something?
Yes, you may.
Sorry.
No, it's okay.
As you can see, I love talking apparently, but yes, I totally agree with you, Marie, that scholars tend to be very critical of courts and so on, and we are in the safe part of it because we don't have to issue judgments and so on. We're not under the pressure. Yes, you're right. However, that also depends on some scholars, in spite of being in that comfortable position, also try to give some tools to judges to help them in their task. And one of the things that perhaps could aid judges in their task is to tell them that in their fact-finding, and this is applicable to the Inter-American Court of Human Rights, they could try to be perhaps less colorful. Why do I say this? Because it has happened, for instance, that there are two situations that I remember because I wrote about them, that the court, for instance, in one case, when it established the facts, it said, and this person was shooting for several minutes, I don't know, like with a machine gun or something like that. And I thought about it, and I said, okay, let's sit for several minutes and imagine. And you could say, would that person be necessarily shooting for several minutes? Wasn't it the case, perhaps, that the victim who was there hearing the shootings thought that this shooting was endless, and that's why that person perceived that the shooting lasted for several minutes? And I wondered, well, in this case, this particular fact, which wasn't necessary, it's just to add a colorful retelling of the story, was based only on the declaration of the victim, of the victim, and therefore you could say, okay, perhaps a court should try to restrain itself and give not that colorful facts, because they are not relevant and they are going to be subject of criticism if they use that standard of proof, which would be like very slight, even below the standard of probabilities, for saying something that is actually not useful. It's not useful for the story, regardless of whether the individual shoot it for several minutes or shoot it for some large
5
number of seconds. Yes, the violation was equally committed. And that adds to, you could say, to give a lesser credibility to the rigorousness of the court that finds on those specific subjects. So perhaps an advice that we could give to courts is to try to stick to the facts that are very strongly proven with the standard of probability, the preponderance of evidence. That's 51% of probability, and stick to those facts, because that is first going to make you use less time, and also second, help you maintain your rigor. So that's just to help judges.
Yeah, I mean, I am convinced by your argument as I hear it, but then there is a little voice at the back of my head who also says, well, you know, okay, you say in any case it doesn't make any difference to the finding by the court, and I take your point. The violation will be found with or without that detail being added. But if the court, in a sense, tries to remain to just the objective facts, which are not colorful, to use your qualification, in a sense, if we believe that the function of the court is also to hear the victims and to kind of give them a voice, but without giving them a complete voice, but nonetheless to have a judgment which resonates with their experience, the piece of advice that you give is going to make it more difficult for the court to express what the victims have been trying to express. So I think even there, it's always a balancing exercise, and maybe we'll have different courts, different judges who are going to decide to do it in different ways, and that there is not one size fits all. But that, you know, they need to be aware of, in a sense, of both risks. That on the one hand, if they go too far, they're going to add things which they have no evidence for and may be mistaken, but that if they go overboard by eliminating the all the elements which give more flesh to what they are saying, one dimension is also kind of being forgotten.
Yes, that's a fair point. But perhaps the European Court of Human Rights strikes a fair balance on some of these matters, because it sometimes says that the victim claims this, and that. So it recounts what the victim claims, but as being claimed by the victim. So in that sense, you could say it is hearing what the victim says, it's giving the victim a voice.
And actually, when you were giving that example, I was thinking, oh, the court could have rephrased, you know, with which witness, blah, 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 said lasted a number of minutes, because then the source is indicated, and it was, did the victim get it right? Did it get it wrong? We don't know.
Yes.
So we've discussed a little bit the difficulties around incorporating the testimonies of the victims, and maybe a similar issue or a challenge could emerge if we discuss affidavits. But I actually want to discuss the another point, which is that in some cases, the Inter-American Court of Human Rights will rely on state acknowledgement of the facts to itself, to dismiss basically the findings of the domestic courts and to establish the facts. And Álvaro, I believe that you believe in some cases, this leads the court to establish facts too quickly, and without, let's say, without sufficient care. So could you maybe explain a little bit what you mean by that?
Well, the taking into account what Marie said, that the court, that many consider that the court is also supposed to give voice to people whose voice has been quashed and so on. The court considers that it has the role of establishing the facts, even in cases where the state acknowledges the violations. So in the case of the European Court of Human Rights, whenever the state acknowledges the facts, well, the case ends and compensation is given and so on. That's how I understand it still works, doesn't it? Doesn't it?
It is supposed to work that way. I mean, that's now, you know, as you may know, I've worked extensively on the Ireland versus UK case of 1978, which involved the British authorities. I would say the European Court did not say that, but I would say torturing IRA members through the techniques of sensory deprivation, so being against the wall, not being given food or drink or not enough, not sleeping, hearing a noise all the time and having to be against the wall on your toes, so with quite awful consequences. And in this case, where the European Commission of Human Rights found unanimously that this treatment had amounted to torture, the UK government went to Strasbourg saying that it did not contest the findings of the Commission. And despite that, the court went on to review everything and to say by the end of it that it didn't think that the intensity of suffering had been strong enough to amount to torture. So in my reading of the case, the UK thought it was going to be found in violation of the prohibition of torture. It accepted that that was what was going to happen. It didn't want to have to explain itself before the court because it was too worried about what would come out. So it didn't want to contest the case, and despite that, the court went on to examine the case and to find no violation, which goes to show how much the court did not want to find the UK in violation of the prohibition of torture. So it's very political, ultimately. So, but it may be an example which confirms the rule, an exception which confirms.
Okay, yes. So that's a fair point. But so as you say, generally that's the situation. So if the state acknowledges its responsibility, the case ends. But there's no finding of the facts. But that's not the case before the Inter-American Court. So the state acknowledges its responsibility, and in spite of that, the court says, okay, as some sort of responsibility of doing justice, we need to spell out the facts as it happened. So it engages in the assessment of evidence, regardless of whether the state acknowledged the facts or not. And well, that also happens often because the state may acknowledge some facts, but not others. So the court says, okay, we're still going to take a look into the facts. And the problem that I see with that is that one of the principles of justice systems is that you need to follow the principle of audiatur et altera pars, hear both parties in order to find the truth. See what one party says, what the other party says, and try to use those things to find the truth, those statements to find the truth. But the problem is that it's very complex to try to find the proof if only one party is the one that is speaking and the other party is simply saying, yes, okay, that other party is right.
Which is what in a sense the Irish case shows as well. I mean, the UK didn't want to have to defend itself.
Yes, and the problem that I see with this is that that sometimes the state is supposed to be representing internationally, although not necessarily is going to be the case, but the interests or the rights of individuals who don't have the capacity to appear before the Inter-American Court to defend its position. Now that this happens with clashes of rights, and let's say the first case that comes to my mind is the case of the Last Temptation of Christ. I don't know if you remember that case. It was a case in Chile where some people appeared before courts because they wanted to prevent the exhibition of the film The Last Temptation of Christ. This is something that happened, I think, in the early 90s. And the courts in Chile said, okay, you claimed domestically and you used a human rights proceeding to ask for the prohibition of this film because of your right to honor. Okay, so we're going to prevent the exhibition of the film. The people who wanted to see this film went before the Inter-American System of Human Rights, claiming the right to freedom of expression. Internationally, this was a case only of a right to freedom of expression, and the state was supposed to be arguing the other position. Because of some political reasons, actually the position of the state coincided with the position of the of those who wanted the film to be exhibited. And the problem is that the interests or the rights that were beneath the at least formal position of the state didn't have a voice before the Inter-American System of Human Rights. So that's why I think that it is problematic, this idea of stating the facts in spite of the state acknowledging its responsibility, because you're never able to hear the interests or the rights of the people who are beneath the formal position of the state. And that may make the finding of facts a little bit more difficult. And it has happened in some cases that the definition or the decision of the court could have had some results, or the reparations of the court could have had some results domestically. And that's why some people have wanted to intervene before the Inter-American System of Human Rights to tell their part of the story. And they haven't been allowed to because of procedural reasons. There's no third-party interventions before the Inter-American Court of Human Rights unless it is as amicus curiae. So, so the relation of this with the facts is that the court should take into account its limitation when the state acknowledges its responsibility, because there is something epistemological of hearing both parties if you want to find the truth. And that's why I'm a little bit critical of this idea of spelling out the facts as they occurred. It is true what Marie says, that the court is also supposed, at least by many people, to give some sort of have some sort of healing effect to the victims, and that's why recounting the facts is something good. However, you should try to strike a balance with this sort of epistemological limitations of cases where the state acknowledges its responsibility, and simply this idea of not saying anything. I don't know if I make myself clear, Isabella, with this, because it's not something that's straightforward, but what I'm saying is that there's a limitation, an intrinsic limitation of trying to say what the truth is without hearing really the other party. Because in this case, it's not really the state who is, I mean, it is procedurally the state, but there may be some rights underlying the position of the state.
And of course, it's difficult to say the truth, even if you hear both parties.
Of course,
Yes.
of course, of course.
And this is also, I mean, we've also seen the issue with like not having the fact that you can't have a third party present also at the European Court. Not at the European Court of Human Rights, at the UN treaty bodies with the Sami case, with a similar issue where the state is not actually representing the interest of the other party, if that makes sense. So I understand the point that you're making. Okay, I think we have gone over time quite a bit. So thank you very much for the very interesting conversation. I think there's a lot to unpack. And I think this also gives a really good overview of the evidentiary challenges, not only at the Inter-American Court of Human Rights, but in all the regional human rights courts. So thank you very much, Álvaro Paúl. Thank you, Marie,
Thank you for the
for participating.
Thank you.
Thank you for the invitation.
Thanks a lot.